Hello, everybody. I'm going to start the seminar now because obviously the aim of this seminar is that we can conclude it in your lunch break. I think we probably still have some people joining, but if I can just by way of introduction, tell you who I am. My name is Stephanie Harrison. I'm a member of the public law team at Garden Court Chambers. I'm also one of the 3 heads of chambers. The seminar that we're preparing, we're delivering today, as you're aware, is on the very important duty under Section 149 of the Equality Act, the public sector equality duty. We are very fortunate to have 3 speakers, Miranda Butler of Garden Court Chambers and Nicola Braganza of Garden Court Chambers, as well as Leona Bashow from the Equality and Human Rights Commission. This is the first of 2 seminars, this one taking starting this week on the overview, case update and practicalities in terms of funding, and it is to be followed in 2 weeks' time by a second seminar, which I'll give you more details of at the end, and we'll look at in depth at some other topics. So before we get to the substance, as you're familiar with this format, everybody is on mute, but we do have a question and answer box in which we could request that you, if you do have any queries or questions, that you include them, and we'll have time at the end to address them. If we run out of time, then we'll certainly make sure that we respond to any questions in writing. The papers that people are going to deliver by way of slides will be provided to you after the seminar. And in terms of the seminar itself, it is going to be recorded, so I hope that everybody's happy with that. And then it will be available for those who couldn't attend the seminar today. So I think that's all the technicalities I need to talk about. If there are any technical problems, you could put a question in the chat, and Amy Hughes, who assists with those matters, will try and help if she can. So if we can then move on to the substance, and can I just introduce for you Miranda Butler. Miranda's going to talk about the statutory framework. Miranda is a member of the public law team. She has a broad public law practice with an emphasis on migrants' rights. You will have got more detail about the sorts of cases that she does, but most recently she's been involved in a case in the Supreme Court challenging the fees for nationality applications from children. And just very recently, coming up next week, is a case concerning the right to work for victims of trafficking under the NRM, and she is a member of the EHRC's panel council, obviously therefore with expertise in discrimination law. Miranda.
Many thanks for that introduction, Steph. So I'm here to provide a fairly short introduction to the PSCD. I'm sure that some of you will be very familiar with all of this, and so I hope it will be a useful refresher for the experts and a gentle introduction for the less expert amongst you. So I've started here with an excerpt actually from the EHRC's website, which answers the question about why we have the PSCD. And I thought that this was a useful summary of the purpose of Section 149, which is quite distinct from the other provisions in the Equality Act. And its purpose is to integrate consideration of equality and good relations into the day-to-day business of public authorities. It's trying to ensure that public authorities consider how functions can affect different groups in different ways. It's requiring public authorities to consider how groups can positively contribute to the advancement of equality and good relations rather than simply avoiding harassment or discrimination. It's therefore a proactive rather than restitutionary provision, which is intended to grow a culture of not only human rights protection, but equality protection throughout government and throughout all public authorities. And it's worth bearing that in mind as we look at the somewhat detailed provisions. So the provisions of Section 149 require a public authority to have due regard to the need to eliminate discrimination, harassment, victimisation, and other prohibited conduct, to advance equality of opportunity between persons who share a relevant protected characteristic and those who don't, and finally to foster good relations, between persons who share a relevant protected characteristic and those who don't. This is only a duty to have due regard. This is not a requirement of perfection, and therefore the impact of a finding of a breach of Section 149 can be somewhat limited, because it merely requires a public authority to go away and effectively look again at the matter. But nevertheless, as we can see, these are extremely broad matters to which all public authorities, or excuse me, I'll come on to the exceptions, many public authorities must have due regard. In terms of that definition, having due regard requires public authorities to consider the need to remove or minimise disadvantages between suffered by people who share a relevant protected characteristic that stem from that characteristic, to take steps to meet the needs of persons who have a relevant protected characteristic that are different from those who do not, and finally to encourage people who share a relevant protected characteristic to participate in public life or in any other activity. So once again, what we're seeing here is a proactive duty that is meant to facilitate and further the well-being of individuals with protected characteristics and their integration into society. And when it comes to disabled persons, that requires a positive steps to be taken to take account of individual disabled persons' disabilities. Finally, the duty to foster good relations requires a public authority in particular to have regard to the need to tackle prejudice and promote understanding. So whilst much of Section 149 is focused on making sure that harm is avoided, there's also a concomitant provision to seek to, as well as protect those protected characteristics, to promote and further the understanding of those who do not, ensure that that any prejudices are tackled. As I've already repeated several times, the PSED applies to public authorities, but that's a fairly broad and substantive definition. It extends to those who exercise public functions, who would not otherwise be treated as public authorities, but where they are acting as though they are a public authority, where they are in fact exercising public functions. They have to have due regard to the matters set out in Section 149. And this is broadly similar to the approach to public bodies that you can see in the Human Rights Act. It's worth noting here that there are detailed provisions about the nature and extent of public authority set out in Schedule 9 to the 2010 Act, including the fact that certain public authorities have obligations in relation to all of their functions, and in relation to other public authorities, it's limited only to specific functions. I'm sure that everyone here is familiar with protected characteristics under the 2010 Act, namely age, disability, assignment, pregnancy and maternity, race, religion or belief, and sex and sexual orientation. But it's worth noting that several of these are subject to an exemption when it comes to Section 149 in certain specific areas. And so coming on to those exemptions, which are set out in particular in Schedule 18 of the Act, firstly, there is an exemption precluding application of the PSED regarding age in the broad areas of education, benefits, facilities and services to pupils in schools, community homes, and children who are being accommodated under Section 82 of the Children Act. Secondly, and as is very relevant to my practice, when it comes to the exercise of immigration and nationality functions, the PSED has effect as if it's subsection 1b did not apply to the protected characteristics of age, race, or religion or belief. And significantly here, race incorporates both nationality and ethnic or national origins. And so this significantly restricts the applicability and force of section 149 in a broad range of immigration and nationality functions. But it certainly does not mean that all matters that might be related to immigration and nationality functions are excluded. There was a case recently, for instance, concerning the failure to provide COVID accommodation for undocumented migrants in the UK, which made substantial reference to the PSCD, despite it involving, at least indirectly, the exercise of immigration and nationality functions. And you'll see I've noted on this slide that Schedule 18 provides detailed guidance on what constitutes immigration and nationality functions, and also provides certain areas where an exemption applies, for instance, where a body is carrying out a judicial function. I'm sure that many of the practitioners here will be very familiar with the duty to raise the PSCD claim. And as I've already indicated, the duty under section 149 is a procedural one. It is a duty to have regard. It is not a duty to achieve a certain outcome. I'm just going to close by focusing on two key cases that really should be the starting point for anybody delving into this area of law. Firstly, the Supreme Court's decision in 2015 in Hotak versus Southwark, where it reviewed some of the relevant judgments in this area from the Court of Appeal in the process of considering the Housing Act 1996 and who should be treated as vulnerable for the purposes of assessing priority need when housing individuals. The court endorsed some of those judgments and drew a few broad conclusions about the application of the PSCD. As I've already mentioned, it emphasised that the PSCD is not a duty to achieve a particular result, but rather to have due regard. It also noted the legislative intention behind this provision being to build a culture of greater awareness of the existence and legal consequences of disability. Of course, that case particularly focused on disability given the statutory framework it was dealing with, but that principle applies equally to other protected characteristics. And that legislative intention is relevant to the application and interpretation of the PSCD, particularly in light of the guidance that I'm about to come on to in a relevant Court of Appeal case. Finally, the court emphasised that the extent of the duty is highly fact sensitive and independent on individual judgment in the particular facts of the case. And so once again, this is not a single threshold that public are required to achieve in every case. Rather, it is a fact-sensitive assessment that requires a public body to have due or sufficient regard in the circumstances to the matter set out in section 149. Finally, bracking, which is now of some age, but remains one of the most useful statements of the nature and extent of the PSCD. It emphasised that section 149 is not some add-on to the 2010 Act, but rather the positive and proactive duties therein are an integral and important part of the mechanisms that are intended to help develop a culture of anti-discrimination and equality beyond merely prohibiting certain conduct. It also emphasised, and this is a key point for practitioners, the evidential element. Whilst there is not necessarily any requirement to have a formal written record of the steps taken in compliance with section 149, in many cases that is key. And certainly in many of the cases that I've dealt with, including the case concerning asylum accommodation I referred to earlier in this talk, the availability and quality of the assessment made by the public body was considered in some considerable detail by the court when looking at the matter of the compliance with the PSED. The duty under Section 149 is on the Minister personally, and their obligation is to assess the risk and extent of any adverse impact and the way in which such a risk might be eliminated before taking the step in question. There can be sometimes a temptation, perhaps, and you see this in litigation, to explain a decision by reasoning and analysis post it. But this is not a retrospective process. This is a proactive and preemptive obligation on public bodies. The Court of Appeal also emphasised that the duty has to be exercised in substance, with rigour, with an open mind. It's not a mere tick box exercise. And whilst, as I've already indicated, there's not a duty to make express reference to the fact that you are considering the Section 149 duty, reference to it and a written record of steps taken will likely reduce the scope for argument that there hasn't been compliance with Section 149. So that has been a truly whistle-stop tour through a somewhat complex piece of legislation. But I think the key takeaways here are the starting point, really, which is that legislative intent to create and grow a culture of anti-discrimination and equality, and the need to engage seriously and proactively with those duties. I'm now going to pass over to Nicola. Thank you very much.
Thank you very much, Miranda. Yes, we're now going to hear from Nicola. Nicola has a very broad ranging practice that focuses on all aspects of equality, discrimination and public law, which also involve human rights challenges and immigration. One of the very important recent cases that she was involved in was a challenge to the Ministry of Defence, which did have an equality impact assessment or Section 149 aspect to it. And it concerned the treatment of women in the armed forces and the handling of sexual violence offences. And although, as we've heard from Miranda, that the duty itself is a procedural duty, it can lead to very significant consequences if it hasn't been complied with. And one of the consequences of the litigation that Nicola was involved in is that there has been an inquiry launched by the Defence Committee in Parliament on women in the armed forces from recruitment to civilian life, so it can have practical consequences when those duties haven't been complied with. As well as a case law practice, Nicola speaks regularly. She spoke recently at an International Women's Day event, A Step Back for Equality, COVID-19 and the impact on women's socio-economic rights, and in focusing on the disproportionate impact of COVID on women in both the domestic and international context. And of course, the interrelationship between the different duties and the socio-economic rights of people, the way in which discrimination interacts is obviously a very significant, complex, important issue. Most recently, Nicola, along with a number of other women from Garden Court Chambers, was involved in the Cedaw People's Tribunal, again focusing on the international aspects of duties to challenge discrimination against women and girls, and judging whether or not that the domestic law had met any of those international obligations. So with that introduction, I'm going to ask her to talk about the case law.
Thank you, Steph, and thank you, Miranda. Right, I'm going to start by hopefully successfully sharing my screen.
Yeah, that's worked.
Yeah, excellent.
Yeah, that's fine.
Okay, great, brilliant. So I'm going to go through a case law update of PSED cases over the last 12 months. I did a check and there are more than 40 cases, so I'm not going to be speaking to 40 cases. I've drawn out about 11 cases, and from those drawn out particular points that I think are really helpful to highlight whether you're bringing a claim, so to have those in mind when you're framing your argument, or defending a claim. And so I begin with a case reported yesterday, called Sophia Sheikh and against Lambeth, concerning orders about restricting traffic in low traffic neighborhoods, which inevitably will have an impact on people with disabilities. And Sophia Sheikh was disabled and heavily reliant on her car. She challenged the PSED and said that, in fact, Lambeth, in implementing those orders, had failed to comply with its duty. She relied specifically on the equality impact assessment, not specifically addressing the impact, and that it was inadequate, following on from Bracking, which, as Miranda took you to, is essentially the Donoghue and Stevenson of PSED cases. And countering that, Lambeth relied on two cases, Hollow and Hurley. Hollow set out that what constitutes due regard will depend on the circumstances, again, echoing what Miranda took you to on Bracking. And Hurley, again, setting out that the concept of due regard requires a proper and conscientious focus on the statutory criteria. The decision maker must be clear precisely what the equality implications are when he puts them in the balance. He must recognise the desirability of achieving them, but ultimately it's for him to decide what weight they should be given. So yeah, as you'll see throughout, it's all about, yes, of course, have regard to it, but at the end of the day, as long as you can show some evidence of having had regard to it, even if the ultimate outcome essentially is discriminatory, the PSED will have been met. And Mr. Justice Kerr, again, echoing what's been said in Bracking and Hotak, set out what amounts to due regard as fact sensitive. If the equality objectives are properly considered and put in the balance, it's for the decision maker to decide how much weight they should carry. It's a duty, again, set out throughout the case law. It's a duty to what can be called, to have regard to what can be called the equality objectives. Assessment is the tool used to create the evidence base to show performance of the duty. And then going to the explanation as to the context in which the PSED had to be considered, Mr. Justice Kerr set out was the coronavirus epidemic, the resulting statutory guidance that led to abandonment of conventional and leisurely approach to introducing LTNs. Secretary of State urged local authorities to take radical and almost immediate measures to enhance walking and cycling. So, and this is the point on this one that I've drawn from this, how does the rolling basis, how is that to be reconciled with compliance with the PSED? And Mr. Justice Kerr set out, there's nothing in section 149 which prevents, in an appropriate case, performance of the duty by means of a conscious decision to undertake equality assessment on a rolling basis. A decision to do that is not contrary to the prerequisites of Bracking, but 164, a decision maker who decides to proceed on a rolling basis does so at their peril. The legislation in case law does not preclude rolling assessments, but neither do they legitimize it for all cases. The more evolutionary the function being exercised, the more readily a rolling assessment approach must be justified. Conversely, for a one-off function, it's hard to see how it could be justified. And then he clarifies and says, I should make it clear, I'm not deciding that a rolling basis is always acceptable. It may or may not be. So we always come back to this case sensitive, depending on each case, to see whether it's sufficient to pass the test of due regard. Next case of Moore. So this was an appeal from Mr. Justice Swift, who had dismissed the application for judicial review concerning the different treatment between maternity allowance and statutory maternity payment when it came to calculating universal credit. And the argument was that they're not relevantly distinguishable, but they were treated very differently. So maternity allowance was treated as unearned income and deducted in full, whereas SMP was treated as earned income and deducted on a tapered basis. So the claimants ran an Article 14 discrimination point. And then for our purposes, in terms of what I've taken from this case, so the previous one was all about the rolling basis. This one is about out of time. So what reference point are you looking at when you're bringing a challenge to the PSED and the extent to which there was compliance with it? And the claimant's argument was, well, this applies from the time it impacted on us. And the Court of Appeal rejected that and said the challenge was to the process of the decision making leading to the universal credit regulations. This is not accordingly. So the comparison was then made with the case of Badmus. This is not one of the so-called person-specific categories of cases identified in Badmus, where the challenge is directed to the process. The approach, as with any other, is to require the claimant to bring the challenge promptly within 3 months and to make good all application for an extension of time. So you go back to when the process was carried out, arriving at the decision that led to whatever policy or order or regulations or individual decision that you're challenging. Next case, 3 million, which our own Ollie Percy was in. Now, that was refused, and the point, if you like, that this is helpful towards is that the court held it was essentially, in respect to the PSED, a premature challenge. So the application was about the Home Office's policy of digital-only proof of immigration status for the EU settlement scheme. And the court held that it was premature because the decision to implement the policy was not going to be implemented until the 1st of July 21. Until then, immigration status could be verified by physical evidence, and the overall scheme was subject to modification. So what the court said, and you see there in bold, until then, the 1st of July, it's open to the defendant to discharge any additional duty under Section 149 in relation to this aspect. Right, next one. Now, Blundell and Day, 2 cases brought against Secretary of State for Work and Pensions, again before Mr. Justice Kerr, in respect of a deduction to universal credit for the payment of fines under the criminal law, which was applied in a blanket approach. So there was no discretion to it. And what that meant was that because this, if you see there, the facts from October 19, the maximum deduction to 30% was reduced. The policy to take deductions at the maximum level was subject to a cap, but there was no provision for reducing deductions due to financial hardship. And so the individual affected could apply to the fines office or the magistrates to remove the deductions from the benefits order and could enter into a direct arrangement, but the court had no power to maintain the deduction or alter the rate. And this was successful. Well, pausing there. It was successful insofar as the Secretary of State accepted that she'd failed to conduct an equality impact assessment, but, and this is where it's wholly unsuccessful, highly likely the policy would still have been adopted. And so because of Section 31(2)(a) that requires that the court must refuse relief when the outcome is highly likely or inevitable to be the same, notwithstanding the failure to disregard, then the court refuses that relief. And that's what happened in this case, which again goes back to how effective the PSED actually is and to what extent it has teeth when the outcome of it, and then of course the challenges then brought by ordinary discriminatory routes. But in terms of the PSED, if the procedure is being complied with, and then the secondary argument is, well, it wouldn't have made any difference anyway, on that basis, you then face relief being refused. Alternatively, if you're defending the claim, that's how you can bat it off in one. Right, sorry, let's see the next one. And on that, raising the same point, if you're considering it in terms of when relief must then be refused, is Gathercole, which was all about planning permission for a new primary school, and it was the effect of aircraft noise on children with protected characteristics. And the environmental statement showed the design did not take account of the needs of such students. It wasn't picked up in the planning officer's report. There's nothing in the report of the subsequent decision, but it was accepted that it was highly likely, if not inevitable, the planning decision would be no different. And again, it was described as a good example of relief in those circumstances having to be refused under section 31(2)(a), referring to Goring. This court should undertake its own objective assessment, so that's of some assistance. But then at paragraph 8, you see in bold, I've set out the provision is designed to ensure, even if there's been some flaw in the process which might render the decision unlawful, where the circumstances mean quashing would be a waste of time and money, the decision must not be quashed. Tyranny is about extraterritorial application, and effectively that whilst you have a challenge to the extent to which the PSD is being complied with at the decision-making formulating stage, it doesn't have the reach. If the consequences have a reach of extraterritorial application, then the challenge failed. So Tyranny was a case concerning the exclusion of Palestinian refugees from the Vulnerable Persons Resettlement Scheme. The facts were that the refugees fled from Syria to Lebanon, and they appealed against the dismissal of the JR because essentially the scheme that they were denied access to referred to UNHCR, but they were registered with UN Relief and Works Agency, and the UNHCR had no mandate over the Palestinian refugees registered with UNRWA, and the High Court held the scheme was not indirectly discriminatory. The PSD applied to the decision to establish the scheme and had been a breach of duty. Appeal was dismissed, cross appeal allowed on Tyranny, and held that the PSD applied to the formulation. This is what I was saying before. The real question was whether the duty extended to having due regard for promoting equality outside the UK. Referring to what Parliament intended, Section 1491B suggested that there was nothing there in the express wording, that Parliament intended there to be this extraterritorial reach, and requiring a public authority to have regard to the equality needs outside the jurisdiction would, and whose equality of opportunity would have limited scope to influence, was not implicit in the statutory scheme. Judges' criticisms in the court below on HOTAC, so this is not HOTAC in which bracking was followed, but HOTAC, a different case in Horo, were correct. HOTAC and Horo were disproved. Two cases to watch that are currently being appealed. Motherhood Plan was the first one, also known as Pregnant Then Screwed. That was a challenge to the Self-Employed Income Support Scheme, and to specifically the mechanism by which the Treasury calculated the basis for individual applicants to be eligible for the scheme, to apply for payments under the scheme. And the method was the average trading profits of the individual's business over the preceding 3 full tax years, namely 2016 to 19. And the claimants who Pregnant Then Screwed, a campaign for and provider of legal advice to pregnant women and mothers, that argued there's no EIA pre-deciding that approach, and they were unsuccessful. The appeal is pending. Mrs. Justice Whipple set out, again, what we all know. It's procedural. It's not a duty to achieve any particular result. A court should not go further than to identify whether the essential questions had been conscientiously considered and any conclusions reached were not irrational. The general equality implications, as well as the particular position of mothers who had recently taken maternity leave, had been properly and conscientiously considered. So that was booted out, and that's gone up to the Court of Appeal. Next one, watch this space, is United Trade and Transport. That was all about, so that was successful. The Mayor's Street Space Plan and interim guidance. Again, dealing with these temporary traffic management orders, and the proposals to prevent or restrict vehicular access widely across London streets have potentially adverse effects upon people with protected characteristics, specifically disabilities. And here, so this is maybe adding a little bit of teeth to the nature of the procedural duty. the court set out there should have been a conscientious assessment of the risk and extent of adverse impact. So that takes us back to it not being a tick box exercise. And following bracking, once the plan was announced, it was embedded in the guidance. An inequality impact assessment was published before the TMO. It did not meet the required standard of rigorous and conscientious. And I think it's helpful, so that's why I've set it out. Paragraph 193, the court said, the mitigation entry, safe impact, and the implementation explanation were perfunctory or non-existent and failed to grapple with the serious negative impact. So that's all about really going back to your EIA and seeing, when you tear that apart, whether you can actually point to the fact that it's lip service is just being applied to it rather than a proper conscientious approach. And I think it's helpful. And again, that's why I've put it in bold, that the court said, most worrying of all, the equality impact assessment read as if its purpose was to justify the decision already taken, so which in my experience is more common than should be the case. Possession proceedings, very briefly, many of you might be familiar with Taylor and Cedaw, and that set out the importance of prospective compliance. This was all about a tenant with bipolar, a diagnosis of bipolar disorder, and whether the local authority had breached its PSED in respect of possession proceedings. And there, the distinction is specifically made that the considerations are different in the context of possession proceedings. And it's helpful, this case, because it sets out the possibility of PSED breach at an early stage. In possession proceedings, it can be cured. So I've drawn on this case for that point, where the curing a breach post-breach, and that is open to your public authority to do. So subject to the proviso, though, that the public authority has to comply with the duty in substance with rigour and open mind, and a subsequent purported compliance was not tainted by the incentive not to depart from a decision already made. Education, so those possession proceedings, education, again, many of you will be familiar with ZK and Redbridge. Now, this is helpful because what it's saying is don't duplicate what you're looking for, what you're looking to achieve. So if there's a specific requirement, a statutory obligation to addressing the particular protected characteristics, then you don't really have substance to a PSED argument, because actually what you're doing is you're labeling the same thing by a different name. And so ZK Redbridge refers to MacDonald and says, where a public body discharging its functions under legislation expressly directed at the needs of a protected group, it might be unnecessary to refer expressly to the PSED. So I would there, when you're coming from the point of view of bringing the challenge, focus in on distinguishing, making a distinction between what the express provisions provide and whether in that there are other protected characteristics that there's not been due regard towards. And if you're defending a claim, then that's to say that actually it's been sufficiently met in terms of the procedural requirement. You've had due regard, and in fact you've had more than due regard, because you've expressly followed specific legislation on it. And I'm going to finish with Bridges, because I couldn't not. Bridges, of course, a brilliant success in the Court of Appeal, and I'm sure you're all familiar with the facts. It was all about a pilot project on automated facial recognition, where actually there wasn't proper thought as to how it could impact on particular protected groups, specifically race and gender. Surveillance cameras were going to be put in use to capture digital images, and they were going to be used to see if they match police watch lists. And once they'd been used, if they didn't match, they'd be deleted. And the Court of Appeal held that, first of all, on the discrimination, on the substantive discrimination argument of Article 8.2, wasn't in accordance with the law. For our purposes, the Court of Appeal held that there was a breach of the PSED. The police, the South Wales Police, had not taken reasonable steps to investigate whether the technology had a racial or gender bias. I've set out there why it's important. I think it's really important to come back to this. It requires the public authority to give thought to the potential impact of the new policy, which may appear neutral, so the indirect discrimination line. What's the purpose? It's a salutary requirement that this provision must be seen as an integral, important part of the mechanisms for ensuring the fulfillment of the aims of anti-discrimination. So again, not just lip service, not just for the sake of it, there's actually a thinking behind it, and it's meant to eliminate discrimination. What about if there's no evidence? So do you still need to comply with the duty? Court of Appeal said, yes, well, you can't run that argument because then you're putting the cart before the horse. You need to carry out the assessment, because if you don't, how will you know? And that's no answer. And then very finally, and very importantly, well, what about if it's just a pilot project? That's okay, isn't it? No, it's not okay. Court of Appeal said, specifically, especially if anything, it could be said that before or during the course of a trial, it's all the more important for a public authority to acquire relevant information in order to conform to the PSED, and in particular to avoid indirect discrimination. So with that, I hope that for those of you bringing these claims, please go on bringing them, fighting them, coming up with new points. For those of you defending them, I don't know, maybe use the slides. Good luck to all. And thank you very much. That concludes my slides. Thank you, everyone. Right, I'll stop. Sorry.
Anna, I think the message, use it, use it or lose it, possibly in the current environment, where the more you use it, the more likely we are to face the possibility of it being repealed. So I certainly would agree with Nicola about we've got a role to play in ensuring that the duty, important as it is integrated into decision making, and where it's not, public authorities are held accountable for the failure to do so. So our last contribution, as I indicated at the outset, is from Leona, who is a principal in the Legal Advisory and Litigation team in the Equality and Human Rights Commission. She's been involved in a lot of interesting cases, most recently a challenge to grammar school practices with regard to accessibility for the 11+. And she's going to give us an insight and advice on how to bring such cases, in particular to look at the funding of them. Leona, if that's okay, we can pass on to you. Thank you.
Hey, hello everybody, and thank you very much for inviting me to speak today. I'm just going to share my screen. So hopefully you can see those slides now.
Yes, we can.
Thank you. So as Stephanie said, I'm going to talk to you about the options available for funding a legal claim through the Commission, and also give you some information about the other ways in which the Commission can get involved with litigation. So I will start with a broad overview of our relevant powers under the 2006 Equality Act. And then I'm going to explain the funding criteria that we use to make decisions for funding cases. And I thought it would be nice also to give you some examples of the PSED cases that the Commission has been involved with in the past. And then lastly, I'm going to give you an overview of how you can make an application to the Commission if you think we would be interested in supporting your case. So starting with the Equality Act 2006. Now, under Section 28, this gives us the power to fund legal cases, and the types of cases that we can fund are set out in this section. So it gives us information as to who we can fund, as well as the types of cases, and also what this type of funding includes. So I think the key thing to remember here is that we can only fund cases under Section 28 if they relate in whole or in part to the 2010 Equality Act. And we can only fund individuals who are claiming to be victims of an Equality Act breach. So for example, we wouldn't be able to fund a defendant in a discrimination case. Now, Section 28 funding does include all the costs associated with bringing legal proceedings. So for example, the costs of a legal team, court fees, settlement costs, and we will even cover the costs if we lose. Now, the Commission is also very interested and very keen to publicise the work that we do. So every case that we grant Section 28 funding does come with its very own dedicated publicity strategy. And I've just given you a bit of a screenshot here as to some of the follow-up work that we did in the case relating to access arrangements for the 11+. And in this case, after it was successful, we did decide to write to grammar schools to remind them of the duties under the Equality Act. Moving on then to look at section 30. So under this provision, we do have the power to intervene as a third party in cases, and we can get involved at all different levels of court, including at the European Court of Human Rights. And so, for example, that was the type of work that we did with the recent Big Brother Watch case, where that went all the way up to the European Court. Now, as all interveners will know, the key question to ask when intervening is whether or not we will add value to the proceedings. Also under this section, we do have a fairly unique power because we can bring judicial review proceedings in our own name. And I should also emphasize that under section 30, it is different from section 28 because there's no restriction on us in terms of the type of case that we can fund, so long as it's within our remit. So we can support cases that relate exclusively to human rights. Now, I said at the outset that I would give you a flavour of the types of PSED cases that the Commission has been involved with over the last few years. And so there on the right-hand screen, I've just given you a sample of the cases that we've intervened in. And for example, so we might be interested in cases that clarify or strengthen the PSED duty. And of course, I've got the very influential case here of bracking. I have to say I like the way that Nicola described it as the Donoghue and Stevenson of PSED cases. And yes, I would agree with that. And it has been cited in numerous decisions on how the PSED works in practice. But you might have a case that doesn't exclusively relate to the PSED, but is about an important issue. And perhaps the PSED does kind of come up as one of the grounds. So those are also the kinds of cases that we would be interested in, so long as it meets our funding criteria. Moving on then to explain what our funding criteria is. I thought it would be useful at the outset really to illustrate the availability of Section 28 funding in particular from the Commission by starting with a quote from Mr. Justice Kavanagh in the case of Leighton against the Lord Chancellor. And essentially, we are only able to fund a very small number of cases that we consider to be strategic. And as a result of that, because funding is limited, we do apply a two-step process to help us make decisions when we get funding applications. And so the first stage is that we will look to see if the issue falls within our strategic and business plan. And secondly, we will look to see if it meets the criteria in our litigation and enforcement policy. Okay, starting then in the reverse with our policy. You can see from the screen here that I've set out some of the factors that we will consider when we get an application to fund a legal case or to intervene in a case. Now, the Commission will always be thinking about how wide scale the problem is and also what impact we will have. So the bigger the problem, the more likely we are to get involved in the case. If, on the other hand, the issues in the case only relate to an individual or a small number of individuals, we're less likely to use our resources. Now, the Commission works to a strategic plan, and it's revised every 3 years. So we are currently in the last year of this strategic plan, and it's divided into a number of aims. And so the first aim looks at strengthening the equality and human rights laws. And the types of cases that we are interested in this year for funding or interventions, it could be a case perhaps that does clarify or strengthen the application of the public sector equality duty. Now, we also are very interested in artificial intelligence at the moment, and particularly how emerging technologies might be discriminatory. And again, other issues in relation to pandemic response. Under our work aim, we would be interested in hearing about cases relating to discrimination to do with the pandemic, so maybe COVID-19 restrictions, again, the use of technology, and racial discrimination in employment. Under our Access to Justice aim, this is really focusing on ensuring that people have an equal and fair chance to access the justice system. And so the topics that we're interested in this year include perhaps potentially discriminatory legal aid regulations and maybe the experience of domestic abuse survivors in the justice system. Under our education aim, this year we're interested in hearing about cases that have issues connected with the pandemic, so remote learning and catch-up provisions, reasonable adjustments, including charging fees, teacher-assessed grades, and also behaviour policies. If any of these issues also have a connection with race, that's something as well that we would definitely be interested in hearing about this year. Now, our institution's aim is focused really on protecting the rights of, in particular, vulnerable people in institutions and detentions. So the types of cases that we are interested in under this aim could be cases that involve people with learning disabilities or autism and their treatment in detention. Issues perhaps arising in the care setting, particularly if it's to do with pandemic issues, and also racial discrimination in the provision or access of healthcare. So I'd say watch this space because, as I said at the outset, the Commission is in its last year of this current plan, and we do have a consultation plan for August of this year announcing what our next 3 years plan is going to focus on, and it will be a public consultation, so we are asking everybody to get involved. If you're interested in getting involved, I would ask you just to keep an eye on our website. You can also sign up to our newsletter and you will get more information about our proposals for the next 3-year plan. Okay, so finally, if you do want to apply to the Commission for funding, well, I have to say that you're the perfect audience because we only accept funding requests from legal representatives and organisations, so we don't accept requests from individual members of the public. And if you would like to make the request to us, you can use that email address that I provided on the slides. And we do ask that you just tell us why you think your case meets one of the aims under our strategic plan, and also why you think it meets the criteria in our litigation and enforcement policy. So thank you. That's a whistle-stop tour of the Commission's funding arrangements. I don't have anything else to talk about today, but I would just say that those were an abridged version of the slides, so we will be circulating a more detailed version that will have more information about the full range of topics the Commission is interested in this year. And obviously, we're looking forward to hearing from you. And of course, don't forget to get involved in our consultation this summer. Thank you.
Leona, thank you very much for that. We do actually have one question that is in the Q&A that you might be able to answer. And the question is this: it's in the context of the CARE Act and in circumstances where Her Majesty's Prison Service, in conjunction with local authorities, were consistently ignoring their duties under the CARE Act, which in turn impacts on the client's parole application. Is that something that the EHRC would be interested in considering an intervention?
If it had an equality focus or an issue in relation to human rights, that would be something that might obviously come under some of these aims that I've referred you to. So yes, I think certainly make the application, and just I would direct you to look at our litigation and funding criteria, so the policies on the website, and just make sure that you think it slots into one of those aims and that it relates to equality or human rights. Because if it's outside that remit, we wouldn't be able to assist.
Okay, thank you. And then there's one other question, which is: can the EHRC fund both strategic litigation and intervene in the same case?
Well, in the past, we have granted Section 28 funding for an intervener, so Inclusion London, and to intervene in the Leighton case. So technically that was an intervention, but it was by way of a Section 28 funding. I would say that we would normally do one or the other. So yes, technically possible, but I'd say we probably would do one or the other depending on who's bringing the case and what the issues are.
Okay, I think that there was one other question that was earlier on in the Q&A that it's probably worth just answering now, and it was, the question was, who does the 149 duty, what does the 149 duty apply to? And I think that Nicola explained that in her paper, that it was both to policy formulation and to individual decisions. So it's both a systemic and an individual duty. I don't know if there's anything you'd want to add to that, Miranda.
I'm so sorry, my internet just cut out briefly.
Yeah, the question was about to which decision-making functions does the duty apply to? And I've indicated that it's both at a policy level, at a generic level, and also individual decision-making. I don't know if there's anything else you'd want to add to that.
No, I think that's spot on, and that's the point I was trying to make throughout my presentation, about the fact that it's supposed to be about building a culture. Whilst there are some exemptions to the PSCD, it's meant to be broadly applicable throughout the decision-making process, as Steph says.
Yeah, and it may be that a good example was a case that I was involved in 2017, where we challenged a policy decision that had been taken at immigration removal centres to have a lengthy 12-hour lock-in. So detainees were confined to their cells for 12 hours at night. That had an indirectly discriminatory impact on Muslims, because there were prayers that were going to take place during that time, and that meant that they had to take place in the confined cell that had very unsanitary conditions. So we challenged both the policy decision at a general level, but in each individual case, we also brought a claim under Section 149. And the benefit of doing that is not because the breach of Section 149 itself gives rise to any damages. It doesn't. It's a procedural obligation, public law duty. But what it can do, and this is where there is a very important correlation or impact between Section 149 and the substantive equality duties, is that if the local authority or the public authority hasn't complied with the Section 149 duty, it's going to have a much more difficult task in showing justification for the decision. So if you look at a case in the Supreme Court called Coll, and how that case was applied in my case called Hussein, you see how, in fact, there is an interrelationship between the procedural and substantive duty that can be important, because it ultimately can mean that you will get damages if in your individual case you can rely upon the fact that the 149 duty wasn't applied. So it's worth looking at that angle. I think we may have got some additional questions. We're slightly running out of time. If I could just quickly have a look at those. There is a question, Nicola, you could answer this one, about reliance on protected characteristics and whether you can use sex or gender. So you're being told you can only use one as a sex as opposed to gender.
Let's see what it says. Well, it depends on what your case is about, which protected characteristic that you rely on, and also I think it's helpful to well, in the substantive discrimination case, you could also rely on perceived protected characteristics, associated protected characteristics, rather in addition to the actual protected characteristics of the individual complainant. I think, well, in answer to your question, yeah, I mean, it as I say, I think the best way of answering that is, depending on the circumstances, you rely on sex or you rely on gender, and the correlating sections under the Equality Act for that, or and also I suppose there's the third arguable protected characteristic as well, sometimes within those cases, a sexual orientation too. So it depends. Yeah, it would obviously depend very much on what point you're running on it.
Okay, and there's a question then, I think this will have to be our last one from Fabian, Peter Fabian. He says that we are tenants, landlord, and providing accommodation under homeless duty, where the tenant has a disability, HIV, known to be under control. She's not paying rent arrears. She's offered support. She then stopped engaging with the advice agency. We referred her to social services and she declined. We have done a PSED form. Is there anything more we should do under section 149? They're moving to, they have a possession order, and next step is eviction. So in those circumstances where you have a tenant who has a disability, and that may be impacting on their accessing advice, is there anything more that a local authority should do to ensure that they've complied with the section 149 duty? Obviously, we can only deal with generality, not with an individual case, but in terms of what that duty might be, those obligations to the particular person. I don't know if there's anything you could add to that, Nicola.
I suppose again, I would consider the extent of the assessment and whether the assessment complies with the requirement that it's sufficiently rigorous in what it's taking into account and impact. I think without any further detail, and given that we're just speaking in very generalist terms, I don't think there's anything else that I can add really on that. I don't know whether the others want to add anything. I'm just trying to look for I can't see the question in the chat. So that's again, very much.
I think you would have to say it obviously presents a challenge where you want to do your best to ensure that you're taking into account the person's disability. And if it's the disability itself that's inhibiting the person from accessing assistance, possibly, if it is, then obviously that's a challenge you need to be proactively looking as to what steps you can take. I think that's probably the best we can do.
Yeah. I mean, I suppose the other thing I would say is to actually consider your substantive discrimination points as well. Yeah,
that's true. The very last question from Bridget, asking that in a policy decision, so in every policy decision, the duty should be considered as part of the decision-making process, that if we are challenged, we can and should be able to show that we have taken into consideration the duty. The answer to that is yes. It is every policy decision that you've undertaken, you need to do that. And they're about to start a change manager role, which does include policy change. So this seems very important.
Right.
Yeah, we agree.
Good.
So I think that covers all the questions. If we've missed any questions, we will answer, though we'll provide them in writing along with the slides. If you found this seminar useful, and I hope you have, the indications from the chat is that people have. As I said at the outset, we have a second follow-up session on the 13th of July, which will similarly be a lunchtime session. That will consider issues relating to the exceptions, which is quite a complex issue. You had some of it was identified to you by Miranda, and also looking at in more detail the Bridges case, because we will have both Amanda Weston QC and Ollie Percy, as well as Megan Golding at Liberty, who's going to talk about the Bridges case that Nicola mentioned at the end. So I hope that you will be interested in that. The one other aspect of it, which again touches on something that I indicated about the Hussein case that I was involved in, we will be looking at the interrelationship between individual and systemic judicial reviews. So those cases will be covered in more detail in that seminar, if that's of interest to you. If I can thank all the contributors and for everyone else for their contributions in the question and answers, and wish you well in the cases that you bring or defend.